Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're just having the greatest day and you had a wonderful Thanksgiving. For today's story, we're going to do a deep dive into the recent decision by the Fourth Circuit Court of Appeals that overturned Maryland's handgun ban. So, as I'm sure that you're aware, many states, including Maryland, try to restrict what you can do when it comes to firearms. So that is something that is definitely happening. And they are doing that in this case, of course. And they are trying to make sure that you don't have a handgun. But there are rules to this thing, including most notably Bruin, which said that you have to have gun laws that are in conformity with what happened in the past, and you can't just do anything that you want anytime you want for any reason you want. It's not something you can do. So you have to make sure that all that is happening. So we're going to discuss this issue in a little bit of depth. So let's go ahead and read the decision and see what it has to say. All right, we are in the Fourth Circuit Court of Appeals, the federal appeal court. We're on federal issues, namely, what is the Second Amendment? What does it mean? What are its scope? What are its limitations? What does the right to keep and bear arms mean? And other related things. This is the case in Maryland shall issue, a group that I know a little bit because I used to live in Virginia for many, many years, and I was involved in the gun rights scene when I was. And Maryland shall issue, of course, was a compatriot group, and they do good work in Maryland. Versus the Wes Moore, the governor of Maryland, in their official capacity, because we're trying to fight the law. All right, so let's read a little bit about this decision. What window is it in? Uh-oh. What did I do? Oh. Well, I accidentally closed the wrong window. That's not good. Give me a moment, please. Sorry for the disruption. Streaming problems already. Get these streams started. You already have streaming problems. That's how you know that's how you know we're doing it live, people. That's how you know we're doing it live. Oh man. Good morning, everyone. I hope everyone had a fantastic turkey day. I really do. I had a great time with my friend Nate Brody. Nate the lawyer, who lives in Houston now. I'm sure many of you knew he lived in New York, and he now lives in Houston. And we went to we went to the Texas Renaissance Fair together, and we had a very good time on Friday. And then, of course, we had turkey on Thursday, and that was fun too. So that's what I did during my Thanksgiving, and I really liked spending time with him because he's a cool guy. Properties. Properties. There we go. In case you were curious, by the way, this is also a bit of an audio test. I made a few little audio tweaks since the stream that I did the other night because I listened back to it and I could hear my mouth clicking and stuff like that, and was a little bit annoying for some people. And also some background noise, which was a little bit annoying for some people, and also reverb. So in case you're curious what I did technically, first of all, I just put on a noise gate. Simple, right? Because the mic was just unlimited. All right, it'll just pick up everything, display everything at any dB. So no matter how soft it is, as long as the mic will come, it will broadcast it. Right? Well, the problem with that, of course, is it will pick up things like my computer fan. It'll pick up things, like my keyboard and my mouse and such like that. So I just put it in noise gate at negative 30 dB. So anything quieter than that it just gets cut off completely. So if I'm talking at all, you'll hear every word I say. It's just, if as long as I, just sniffs and like soft clicks like this. You won't hear it because it won't be picked up by the mic, or more the point, it will be picked up by the mic, but the software just cuts it off completely. And then also I installed a de-reverb package to take care of some of the room reverb, to help remove some of that out of the audio. So in case you're curious, that's some of the things I did. And also I installed a plugin to allow for multi-streaming to Twitch, which is exciting. I don't know if anyone notices, but that's what we're doing. Anyways, back to the case. This is from Circuit Judge Richardson. If you live in Maryland and you want a handgun, you must follow a long and winding path to get one. Like any firearms transfer, whether a purchase from a licensed dealer, gun show, or a private person, or even a gift to a family member or friend, you must comply with Maryland's registration process. So Maryland is like, no matter how you get the handgun, you have to go through our registration process, which incidentally is not the law federally, and is certainly not the law in every state. You buy it from a licensed dealer, certainly you have to go through a background check. But if you don't go through a licensed dealer, you may not have to go through a background check because the federal law doesn't require it. But in Maryland, you do. Maryland's process requires that you fill out an application with information and wait 7 days to perform the background check. And of course, if you actually want to carry that handgun, you have to get a permit for that too. So all that stuff. But for handguns specifically, before you have to do that, there's also another step. You have to get a handgun qualification license. So before you do the background check, you have to get a special, or before you carry. So you need a background check, you need a carry permit, and you also need a handgun license if it's a handgun. So you have to get a handgun qualification license. Getting that requires, among other things, submitting fingerprints to undergo background investigation and taking a 4-hour-long firearms safety training course in which you must fire at least one round. Then after submitting application for the license, you must wait an additional 30 days before you can start the rest of the process. So you have to get this thing, go through all that, do all the qualification, wait 30 days, go to the store, buy the gun, get a background check, wait another 7 days, so forth and so on. Many steps. The plaintiffs seek to enjoin this, by enjoining, that is to stop, only this additional preliminary step. So the thing that they're trying to stop at the moment is the handgun qualification license step, or at least part of it. And the plaintiff's challenge must succeed. The challenge law restricts the ability of law-abiding Americans or law-abiding adult citizens to possess handguns. The state has not presented historical analogs, which is what we're looking for after Bruin, which incidentally, as I've said before, is exactly how you do the First Amendment analysis. By the way, when you're talking about freedom of speech, for example, right? What is the freedom of speech? How do you know what it is? Well, you look to history, because what were they talking about when they said the freedom of speech? What is it? So you go to history. So nothing sort of fancy there, right? The First Amendment law, of course, has the benefit of being more well developed because the Supreme Court takes a couple First Amendment cases every single year, and has for many, many years. You know, since about the 1930s or so, when they discovered the First Amendment existed. Before that, not so much with the First Amendment. But around 1930, I guess the Supreme Court finally got that far in their Constitution. They're like, wait a second, there's a thing called the First Amendment. We're just discovering it, and started taking it seriously. And ever since then, they've taken, some cases every single year. Thank you, Jules Buddha, for the 20 gift memberships. It is extensively appreciated. Thank you. So the Second Amendment does not have as much love. We've got Bruin, and we've got McDonald, and we got Heller, and that's about it. And then if you want to go way back, you got Miller, which is kind of a trash opinion. I mean, it's just poorly written. And it has a weird history. Cruikshank, I guess. And that's about it. The Second Amendment cases that are notable, you can count literally on one hand. It's like I've read them all. It's not, So it just needs love. Anyways, the challengeability They've not presented the historical analog. Indeed, it seemingly admitted they couldn't find one. Under the Supreme Court's new burden-shifting test for these claims, the claim must fail. Plaintiff brought the Second Amendment challenge to Maryland's handgun licensure law of 2016. The district court originally dismissed for lack of Article 3 standing, but we reversed and remanded. So initially no standing, but they said, they're standing. It's a group. Organizational standing can get a little tricky, but okay. On remand, the district court again rejected the claim, this time holding the law did not violate the Second Amendment. So they appealed again, presenting us with the merits. The law at issue, which the parties call the handgun qualification license test requirement, originally operated as one component of Maryland's Firearm Safety Act, as now found in the Maryland Code. The relevant law says that no one may sell, rent, or transfer a handgun unless the recipient presents a valid permit. So in simple terms, the challenge law imposes criminal liability on both parties to a handgun transaction sale unless the recipient has the required license. The law then defines how someone might get this license. There are 4 requirements. The applicant must be at least 21 years old. My stream title has a typo, does it really? Let's see. Maryland's handgun ban struck down. Deep dive. Where's the typo? Maryland's handgun ban struck down. Where? Deep dive, lawyer reacts. Looks right. Where's the typo? What am I missing? It says struck down, not struck. It says stuck down, not struck. You are right. It is missing an R. You are correct. It is missing an R. I will fix that in post. Thank you. Okay. The applicant must be 21 years old. He must be a resident of the state. He must complete a firearm safety training course and must undergo an investigation, that is a background check, to show that he's not a prohibited federal or state law from purchasing a handgun. If applicant meets these 4 requirements, fills out the application and pays $50, the state police shall issue him a handgun qualification license within 30 days. Why 30 days? I don't know. Plaintiffs argue the scheme violates the Second Amendment. The district court disagreed, holding that it passes intermediate scrutiny, which is not surprising, by the way, because a lot of these laws were being done under intermediate scrutiny, especially before Bruin, which, and then they're like, well, it needs to be a substantial governmental interest, which it is. So you always pass part 1 of the test because, handguns are dangerous. So there's a substantial governmental interest. So you pass part 1 without breaking an eye, and then it's just, well, they just kind of hand wave away the narrowly tailored part. Of course it's narrowly tailored. Everything's narrowly tailored. So they were upholding everything on intermediate scrutiny. The courts of appeals were, after McDonald and after Heller, they were upholding pretty much everything on intermediate scrutiny. And it's like, well, this isn't working because they're not taking it seriously. So Bruin, incidentally, says, okay, well, the right way to look at this is history. Not, so the way the circuit courts have been doing this is just fundamentally wrong. Okay. Bruin effected a sea change in the Second Amendment. Before Bruin, the courts of appeal, including our own, used the 2-step interesting balance. We first asked whether the challenging regulation burned protected by the Second Amendment, which is fine, by the way, but then, of course, they never said it was, or even they said it was, but it just didn't matter, right? So sometimes they would say it didn't burn the Second Amendment at all, but sometimes they'd say it did, but then it didn't really matter because then they used the intermediate scrutiny, which requires a substantial interest, which is a gimme, and then they just have to find it's narrowly tailored, and they always did. Yet the Supreme Court held that Bruin was one step too many. In its place, the court supplied an analysis centered on the Second Amendment's test in history. The court explained that when the Second Amendment's text covers individual conduct. The courts presumptively protects the conduct. At that point, the challenge regulation is unconstitutional unless the government can show the regulation is consistent with our history, which fair enough. Fair enough. Only then may you conclude it falls outside the Second Amendment's unqualified command. Bruin applied this framework to invalidate New York's version of its May issue licensing scheme. It concluded that the proposed conduct at issue, carrying handguns for self-defense, was presumptively protected. Because, yeah. The court then examined the historical record and concluded it not met the burden to establish a tradition of broadly prohibiting the public in carrying firearms. So the shall issue thing is bullshit. In New York. How about Maryland? Okay. The court rules that Maryland fails the Bruin test. Huber Forever in chat says, what if you bring the handgun across state lines? Well, the handgun, every state has the ability to regulate this. This is currently the law, right? So your ability to take a handgun into any particular state will be governed by that particular state's law. So I can't answer that globally because it will depend on the state you're trying to travel into and their rules. So, you have to look this up. And as a gun owner who's traveled between states, I looked it up every single time I wanted to travel, just on the off chance that one of the states changed the law. So yeah, you have to constantly look and see what the law is, and it's a pain in the ass. But that's what you do. The first question Bruin asks whether the proposed conduct is protected by the Second Amendment. The text operative clause provides the right of the people to keep and bear arms shall not be infringed. To meet the burden, they must show that they are the people and that the proposed course of conduct is covered by the Second Amendment, namely keeping and bearing arms. At first blush, this seems pretty obvious. The plaintiffs are indeed adult citizens. Sort of, they're not foreigners, not here on a visa, they're not illegal. Citizens. Well, that seems like that covers that ground. So they fall within the grounds of the people. And plaintiffs here sake that they own firearms. Yeah. For law-abiding purposes. Indeed, though the amendment's plain text extends prima facie to all instruments that constitute bearable arms, the Supreme Court has held the specific weapons here, handguns, are protected arms. So there appears to be little room for debate on the score. Yet there are a few wrinkles to iron out. To start, you might know that the amendment text protects only the right to keep and bear arms. While on the face, the challenge law says nothing about whether plaintiffs may keep or bear guns. It only restricts their ability to purchase, rent, or receive them. How then does law regulate your ability to bear an arms? The answer is not complicated. If you don't already own a handgun, the only way to keep or bear one is either get one. Yeah. So you can't keep or bear it if you don't have it. So how do you get it? So you have to acquire it somehow, which means you have to go through this schema. Therefore, it implies a burden on the right of keeping and bearing because it restricts your ability to have the item in the first place. Challenge avenue, the challenge law therefore cuts off all the avenues. So yes, the next brings us to the wrinkle. The challenge law does not permanently prohibit plaintiffs from acquiring or carrying handguns. Instead, it imposes certain requirements. They must meet before they can obtain a handgun. And the only requirements rely on objective criteria, which the plaintiffs admit that they can satisfy. Once they do, the law commands the state shall issue. But even though Maryland's law does not prohibit plaintiffs from owning handguns at some time in the future, it still prohibits them from owning guns now. In order to get a handgun, plaintiff still has to follow law steps. In order to get a handgun, plaintiff has to follow the steps. And although they'll be able to complete each one, it's impossible to do so right away. Plaintiffs can't receive a license to legally acquire a handgun until the state reviews their application, which can take, and I'm pretty sure will take, all 30 days. So no matter what plaintiffs do, there will be a period of up to 30 days when their ability to get a handgun is completely out of their control. In other words, though it doesn't permanently bar them from owning it, the challenge law deprives them of the ability until it's approved no matter what they do, which also presents a bit of a problem. We wouldn't normally allow this for much free speech, although there are some situations, so it's not a universal rule. But if you want to go out and buy a book, for example, it's like, well, you can't buy the book now, but you can buy it in 30 days because the law says you must. You must wait 30 days before acquiring this book. Like, yes, you'll get it in 30 days, but I want it now. And so you're infringing with my First Amendment rights now, or at least arguably so. So, there's that. It's like, well, if you're depriving me of my rights for a day, you're still depriving me of my rights for a day. You're going to give it to me tomorrow, but how about today? Today counts too. Yeah, a right delay is a right denied. At least for the day it is. Yeah. At least for that day it is. It's being denied that day. So yeah. So that could be a problem. That could be a problem. One question at Bruin's first step is simply where plaintiffs have made a prima facie case that challenge law violates the Second Amendment. So they need to show the regulation regulates a course of conduct that falls within the amendment's plain text, the ability to possess and carry weapons in case of confrontation. Nothing in the amendment's text or Bruin says it protects only against laws that permanently deprive the ability, which wouldn't make sense anyway. There's no other right that works that way that I'm aware of. It's like, yeah. Yet under the challenge scheme, an applicant without a firearm cannot possess or carry one until they're approved, a process that can, and I'm sure does, take 30 days. And the law's waiting period could well be a critical time in which the applicant is facing danger. That too. The temporary deprivation is facially plausible Second Amendment violation. Sounds right to me. Sounds right to me. Facially plausible, Yeah. Accordingly, Maryland's law regulates conduct that falls within the Second Amendment's plain text. The challenge thus satisfies the first step of Bruin, and we must proceed to the second step. Has Maryland showed that the law is justified by history and tradition? Let's see. Maryland has not met its burden. At Bruin's second step, Maryland must provide historical evidence that justifies the law. To do this, they may identify a historical analog, demonstrating it falls within a historically recognized exception. Historical analog is what you're looking for, by the way. You're looking for something to history. What is the historical thing? We do this in the First Amendment all the time. Can you pass a regulation dealing with the internet? Well, the internet didn't exist in the First Amendment, but that's okay. We'll just look to what the history was and what is it like. So, that's perfectly fine. But the two historical examples that Maryland cite are not relevantly similar. And it's offered no other history. So Maryland tried two things, but the court in their judgment finds the two things to not be on point. So they're not analogous. They're off point. Indeed, Maryland admits at oral argument and not presented a proper analog for the law, noting that it identified no founding era laws that required advance permission. Let's talk a little bit more about history. Maryland's historical evidence is scant at best. It first asserts that the law is justified by historical limitations on the ability of dangerous people to own firearms. But Maryland points to no laws for support. Indeed, it cites various provisions of the modern U.S. Code that prohibit certain categories of people, including felons, those addicted to substance, and those convicted of domestic violence from owning firearms. Maryland simply assumes these federal prohibitions are justified by historical dangerousness exceptions, and because Maryland says its challenge law is also ostensibly designed to prevent those same groups of people from acquiring handguns, it also falls within the dangerousness exception. Nice try. Though Maryland has not mustered independent historical support for a dangerousness exception, other judges have thoroughly canvassed the record, and they tend to agree that history and tradition supports an exception affording legislatures the power to prohibit dangerous persons from possessing guns. In general, maybe. As it applies to particular kinds of dangerous people, we're going to have a more nuanced discussion about that. But that's not what we're doing right now, right? At the moment, we're dealing with people who are not prohibited persons. So are prohibited persons prohibited constitutionally? I don't know. We haven't done that yet. Can Martha Stewart buy a gun? Martha Stewart, as I'm sure you might remember, was convicted and served time in federal prison for a felony. But it was for financial stuff, not violent crimes. So can she own a gun? Yeah. But even if the modern federal prohibitions that Maryland cite are all constitutional, which, let's see, if, because they fall within the tradition, that says nothing about Maryland's law. That is because the law is not relevantly similar to the laws, which it's not. Because all those people are dealing, at least ostensibly, with dangerous people. People that might have some sort of issue in owning a gun. You know, people addicted to substances, people who are felons, people who are domestic abusers. These are people maybe that shouldn't have firearms, maybe. Is that constitutional? I don't know. But this situation is dealing with law-abiding people. That's Maryland's law. Shimbad gives $5. Thank you for the super chat. So as a Maryland resident, can any past convictions for permitless carry be challenged? Lawsuits, can Maryland residents now open and conceal carry? The answer to your question, can it be challenged, is obviously yes. And many of these laws can and will be challenged in the future and are being challenged both in Maryland and other jurisdictions. Does this mean that you can now just open and conceal carry without a permit? No, it doesn't mean that. That wasn't what was being challenged. This was just dealing with one small part of it. This was dealing with the pre-buying handgun permit. This isn't a carry permit. This isn't an open permit. This isn't a concealed permit. This is a purchase permit. Maryland required you to get a purchase permit to even buy the fire, to even do the background check, to even go to the dealer and do the background check. You need a background check first. You need a background check before you can get your background check. So Maryland required you to get this separate background check before you could do the background check in this permitting process, and that's what was being challenged, that specifically. So that's all this case is speaking to. Those other issues have to wait for another day. For better or worse, we have to do this one step at a time. And so we're just doing this one step at a time. So this speaks to the background check before the background check. Ruin is, and thank you for the super chat. It is extensively appreciated. And thank you again, Jules Buddha, for the 20 gift memberships. Thank you, Alan Parker, for the 20 gift memberships. And thank you, Sardin Sim, for becoming a civilian by hitting the beautiful, beautiful join button. Ruin is clear that historical analogs only justify a modern law if the two are relevantly similar. That's what it would mean to be an analog. That's just what analog means. They have to be, that's what an analog is. They have to be similar. The metrics we use to determine whether the two laws are similar are how and why. It seems pretty good. In other words, we ask whether modern and historical regulations impose a comparable burden and whether that's justified. Here, Maryland suggests the justification may well be the same, prevent dangerous people from getting weapons, but the burden is markedly different. The historical dangerousness laws target people already deemed by the state and subject them to penalties if they possess firearms. They're already convicted, for example. Maryland law operates through an entirely different mechanism. It does not merely identify a dangerous group of people and prohibit them from acquiring handguns. Instead, it prohibits all people from acquiring handguns until they can prove they're not dangerous. It flips the burden. Flips the burden. Maryland law burdens all people, rather than just a class of people whom the state has already deemed presumptively dangerous. Yeah. The point is that different mechanisms also often impose different burdens, and the courts must consider mechanisms the challenge law chooses to carry out its goal when evaluating whether they're relevantly similar to a historical law. Yeah. The modern laws that Maryland has cited and historical laws allegedly supporting a tradition of prohibiting dangerous persons from owning firearms all acted through one mechanism, punishing certain classes of supposedly dangerous people if they don't give up their arms or prove that they're not dangerous. But that's a different mechanism than making every person seek firearm protection. Yeah. Presumptively disarming every person until they can prove they're not dangerous imposes a burden on a far broader swath of people. People who you don't suspect a priori are dangerous. Unless you think everyone's dangerous, which, kind of defeats the whole point of the thing. It's not our place as a court to judge a law's wisdom or weigh competing policy values. After all, the Second Amendment is the very product of an interesting balancing test by the people. Yeah, is the Second Amendment a good idea? Can't speak to that really as a court, but I can say that they already made that decision for us. I literally can't speak to that as a court. It's not for me to speak to whether the Second Amendment is a good idea. They already, it's not for me to reweigh the balancing of whether or not, people owning guns is good. They've already made that decision for me. And I am bound as a judge. I am bound as a judge to their judgment. The people are outrank the judge. Wow. If they disapprove, they can draw up a different balancing test using Article 5's amendment process. But under the current balance, Maryland's law cannot survive. Even assuming historical tradition of prohibiting dangerous people from owning firearms, Maryland chose a different mechanism and imposed a different burden. Maryland's second issue is that the law is justified by a historical tradition of laws requiring training for members of the militia. For support, Maryland cites founding era state and federal militia laws, but the argument is without merit as the laws place no restrictions on acquiring firearms. So did it require people to be trained? Maybe, but it didn't prohibit them from buying firearms in the first instance. Right? Maybe once they got the gun, they had to be trained, but didn't prohibit them from buying guns, so it's not on point. Militia training laws did not burn the Second Amendment right, so they cannot be relevantly similar. Many colonies and early states required, with some exceptions, that able-bodied men of certain ages participate in the militia, and generally required members of the militia to provide their own weapons. Also in the Militia Act of 1793, I think it is, on the federal law, all able-bodied men between, I think it's 17 and 45 if memory serves, are part of the unorganized militia. Congratulations, you too are part of the militia. Who knew? But these militia laws never condition keeping or bearing arms on participation in militia training. Accordingly, these militia training laws impose no burden on the right of keeping and bearing arms. Instead, the service burden that these laws imposed was divorced from gun ownership. You could not get out training just by ditching your weapon. And because you owned a weapon did not mean you had to train. If you're a woman or older man who owned arms, for instance, there was no need to appear on the parade grounds. You only had to train if you were in the militia. In other words, the laws imposed a service obligation on militiamen, not gun owners. The obligation appeared regardless of whether you owned a weapon. So you had to go to the militia whether you owned a gun or not. Yeah. So none of these restrictions placed any ownership on gun issues. Consider, for example, New Jersey, which in 1778 passed a law requiring members of the militia to assemble properly armed and accoutred twice a year in such times and places as field officers, or a majority of them, shall direct for the purpose of training in the absence and training and exercise. And in the case of absence from training, the law imposed a monetary penalty based on rank. New Jersey's law likewise imposed a penalty on militia members who failed to acquire proper arms. You had to buy guns. They made you. New Jersey made you buy guns. Yeah. Like that. Another example is Delaware, which passed a law in 1782. The law required that militia shall be duly exercised and instructed once every month, and required members to bring their own guns. Congratulations, you two are part of the militia. Show up. Like New Jersey, Delaware imposed monetary penalties on any militiaman failing to keep arms by him at all times ready and fit for service. Delaware made you buy guns. They made you keep them in good condition. You had to. It wasn't optional. You must. You must do it. At your own expense, nonetheless. In summary, these laws sanction militia members for both failing to show up for training and failing to bring their own arms. You could not evade sanctions if you didn't own a weapon. And just because you had one didn't necessarily subject to them, because if you aren't part of the militia class, which is to say, at least under federal law, 17 to 45, male, but, you know, just because you own a gun, it doesn't mean you're in those age groups or that sex. Yeah. All that good stuff. Thus, militia training laws are not valid historical analog justifying Maryland's law. Militia training laws impose no burden on the right of keeping and bearing arms. They did not condition possessing and carrying arms on militia training, nor do they limit in any way the individual's ability to acquire firearms. These laws place severe burdens on being in the militia, not on being a gun owner. And because they impose the burden differently, they are not similar. Maryland has identified no traditions that could serve as a historical analog, nor is it presented any other evidence that is consistent with the nation's tradition and history. Because, you know, that makes sense. That makes sense. In Maryland, if you're a law-abiding person who wants a handgun, you must wait up to 30 days for the state to give you your blessing. Until then, there's nothing you can do. The issue is out of your control. Maryland has not shown the regime is consistent with the nation's history of tradition. There might well be a tradition of prohibiting dangerous persons from owning firearms, and who a dangerous person is, by the way, also would have to be looked to by history. Right? You can't just arbitrarily decide someone is dangerous. So again, I don't know for sure that all the people who are currently prohibited, all those are constitutional. I'm sure some of them are, but I'm not sure all of them are. And the only way to know is by looking at the history and tradition in a piecemeal way. That's how you do that. Maryland does not point to any historical laws that operate by presumptively denying all citizens of firearms to keep them out of dangerous hands. The challenge thus must succeed, and the district court's contrary decision must be reversed. And then there is a dissenting judge, which I guess I'll read part of just because I will see. So Barbara over here is not part of the crew. Barbara does not approve of this 2-1 decision. Barbara writes, in face of these challenges to non-discretionary handgun permitting law, the majority fundamentally misapplies Bruin. The majority bases its holding on the premise the law affects a prospective gun abilities to own a handgun now. The law is unconstitutional. Well, it might be because it's depriving them now. And being deprived of a right for a day still counts. Right? I mean, it's not as bad as being deprived of a right forever, but it's still a problem, right? If you're deprived of a right for a day, it's still being deprived of a right for a day. You know, it just goes to the damages, if you like, not liability, right? If I don't know, if we're in a traffic accident, how about that? If we're in a traffic accident and I hit your car, am I responsible? Sure. How much? I don't know. How much damage did I cause? You know, did I merely tap your car? Merely tap your car and your car didn't even move. There's no damage to your car. And maybe I owe you $1, right? Because, you know, there's some tort there for trespass. You know, I touched your car, but no harm, $1. right? Did I cause massive damage? In which case, I owe you a new car, or somewhere in between. Who knows, right? So, being deprived of your right for a day means you're less damaged, but you're still damaged. So, there's that. The sweeping rule flies directly in the face of the Bruins' discussion of non-discretionary shall issue laws not supported by any Supreme Court precedent. Simply stated, the majority's hyper-aggressive view of the Second Amendment would render presumptively unconstitutional most non-discretionary laws. Well, I don't know about most, but at least several to many. Yes. That would be correct. Yes. I don't know about most, but several to many of them would be impacted. So her fears of the parade of horribles is kind of the direction that this is going and should go. Yeah, yes, it would lead to that. You're correct. It should lead to that. That's the correct result. So this is where you're like, the slippery slope, I don't deny it. Yes, you're right, the slippery slope, but this is where we're supposed to go. This is the objective. You have caught onto our plan. In defending the result, the majority attempts to pound a square peg into a round hole by treating non-discretionary shall issue no differently than discretionary may issue. I don't think that's fair. I don't think it's no different. They both infringe. They just infringe in different ways. In may issue, you couldn't get a permit at all, which is obviously because it's a permit deprivation, unless they like you, unless you're one of the favorite sons. So now you can get one. You just are delayed. So it's not as bad. I'll give you that. It's not as bad, but still, it's a problem. This pounding maneuver fails to account for material differences between may and shall. Distinctions the Supreme Court ruled in Bruin would require additional consideration. By failing to incorporate the Bruin framework, my colleagues reached the very result Supreme Court cautioned against, namely casting aside shall issue law because the statute results in some delay. But the delay is unreasonable. And also, why are we doing the background check before getting the background check? That doesn't really make sense. Why are we doing this? In reaching the conclusion, the majority also rushes to final judgment, bypassing the district courts of weighing the evidence of mixed question of law and fact. No, I don't really think that's true. Because if you take the facts as Maryland gives you, right, you can do this in a summary way. I'll take all your facts as true. It just doesn't matter. Right? So there's no facts to be weighed because even if I assume everything in your favor, you still lose. So there's not really a mixed question of law and fact here. Doubling down the lack of judicial restraint, the majority strikes down entire statute without even pressing a reference to presumptibility of severability, and therefore dissent. Okay, they're hyper mad. They're super mad. And they'd like you to know how bad they are. So there's that. There's that. So I thought we could cover that decision today, and I enjoyed that, and I hope you enjoyed that too. But yes, the circuit court is essentially correct, in my opinion. They're essentially correct. Like, look, this is burning everybody. Burning them for 30 days. No reason to do this. Doing the background check before the background check. It is an infringement. It's an infringement on their rights now. And the dissent's parade of horribles is mostly correct. I won't say it's entirely correct. I think they may go slightly too far, but they're on the right track. They're like, most of the laws would be struck down. I don't know about most. Many. Some to many. I don't know about most. But yes, a lot of them are suspect at best. Because, yeah, that's just in the nature of the thing. So, yeah. Let me correct the title of the stream before I forget. Title now has an R in it. How exciting. Well, I'm at it. I'll go change the one at Twitch. Well, no, I'll change that afterwards. All right, I'm going to sign off for now. I hope you have a good day. And until later, my friends, have a great one. Have a great one. Hopefully you're with family. And otherwise, if you're not with family today, maybe take the day and just, reflect upon what you're thankful for. And I will talk to you soon. I hope you have a great day. Bye-bye.